in the past 2 years, including 13 senior managers. Executives from the company said none of the 48 had received any severance pay when they were fired. The BBC's Kim Gittelson reports from New York.
Google revealed the firings after the publication of an article in the New York Times, which alleged that the company paid millions of dollars to senior executives who'd been accused of sexual assault. The newspaper said that Google paid Andy Rubin, the creator of the company's Android software, $90 million as severance after he resigned over allegations that he coerced a colleague into having sex. A spokesperson for Mr. Rubin said he did not engage in misconduct and left Google of his own accord.
You're listening to the news on RTHK.
Good morning. Welcome to Backchat. I'm Hugh Chiverton, your co-host today, Danny Gittings. Danny, good morning to you.
Good morning.
We're talking today about the Hong Kong National Party's appeal against its ban. The party, you may recall, was prohibited from operation earlier in September after being described as a threat to national security and public order. Both party founders have filed their appeals to the Chief Executive in Council on Wednesday, but how likely is it that appeals will be successful? Obviously, they won't, because the people considering the appeal are the people who gave the order in the first place. Should Executive Council members who have already commented on the party, though, recuse themselves? Can lawyers represent them in their appeal to the Chief Executive in Council without themselves becoming liable to prosecution for aiding a banned organisation? Should a judgment like this, or on the right to stand for election, be in the hands of bureaucrats rather than judges? Is it just a way for the government to crack down and avoid our judicial system? Let us know your thoughts. You can leave a message on our Facebook page, Backchat and RTHK Radio 3. You can email us, backchat@rthk.hk. Call us on 233 88266. After 9:20, we're talking about Cathay Pacific, the leak of the personal information of 9.4 million passengers. Joining us for our first topic, we have with us now Avery Ng, who's chairman of the League of Social Democrats. Philip Dykes is a barrister speaking today on a personal capacity, not on behalf of the Bar Association. Executive Councillor Ronnie Tong is on the line. And Lawrence Ma, who's a barrister and chairman of the Hong Kong Legal Exchange Foundation. Avery Ng, you're closest to hand. Let's start with you. Thanks for joining us this morning. Good morning. What do you make of this? What do you make of the process of the appeal?
Without talking about the details of the appeal, let me just be clear that this is the first time in Hong Kong there's a political party has been banned or basically criminalized for forming a political party. Now, using this society ordinance to obstruct opposition voices and parties is nothing new. I mean, if we remember Demosisto, the one that's formed by Joshua Wong, they've been trying to register as a society for years. And basically, the government just used administrative excuse to just leave it be. So for a political party, they couldn't do other normal things such as opening a bank account for drawing up donations or booking venues. So it obstructs people from forming a party or expressing their view. But with this national party, this is the first time that the government explicitly say that you guys cannot form a party, otherwise it's going to be criminally charged. And I worry that this is it's not even a slippery slope, it's a cliff, that there's this invisible red line that's being drawn by the government that, whatever political view you express, you may run into trouble.
Well, the Hong Kong National Party would seem to be in a category of its own. The government came up with a very long dossier, didn't they? Whatever you think of it. They made the point. They said that at various stages in the past, that this party had not ruled out the use of violence, which is rather unusual in Hong Kong. You'd be hard pressed to find other political parties in Hong Kong, right, which have actually laid that possibility of violence.
And this is because it's extremely hard with common sense to justify a case to criminalize Hong Kong National Party, because remember, they are a party that's with unknown members. They never really did anything like substantial apart from posting online.
How many members do you think they've got?
I have 10? No idea. From 1 to
No, we know there's at least 2, right?
Well, at least 2. Yeah, that's it. So there's no. Not even immediate threat. There's just no real substantial actions from these guys, and the government the government basically making a big scene and try their hardest to justify their decisions. So
societies can be, I mean, it's part of the law, the Societies Ordinance, that societies can be not recognised if they are a threat to public order.
Yeah. Well, there you go. So the government is trying to redefine public order.
The police basically have said that they are.
Yes.
Produced all this evidence to show that they are.
Well,
so there is a process.
There is a process, but then it's not justifiable. And again, these are obstructions. These are administrative process. It's not in accordance to any previous prior cases. So the government is using these obstacles to basically threaten anybody that would dare to express their view. And it's not just the people who join the party or form the party, but for anyone that may want to assist the party or the chairman of the party. And it is so vague, and with this red line drawn, that the government can, in the future, choose whatever they want. So today, they determined that by advocating Hong Kong independence by ways of words, is a threat to the national security, then the next day it could be democracy or self-determination.
Okay. Ronnie Tong, good morning to you.
Morning.
Thanks for joining us. Isn't this whole process, the appeal process, is kind of absurd, isn't it? It's ridiculous because we know that the people who made this decision, who ordered this, are now going to sit in judgment on whether they made the right decision or not. Obviously, they're going to say it is.
There are many procedures in Hong Kong by which the law prescribes that there is a right of administrative appeal to the CE Council, and this is just one of them. The Secretary for Security.
What are the others? Are they as important as this, or
I think many to deal with immigration. Offhand, there are other administrative decisions. Pepper, all over our various statutes. So we do entertain appeals from time to time in respect of various issues.
Wouldn't it be better if this was decided by a judge?
Sorry?
Wouldn't it be better if this was decided by a judge?
No, I think the ordinance states it very clear that the fact that you have an administrative appeal to the CE Council doesn't rule out your right to go to the court at any point of time. In particular, I think under Chapter 1, there is clear provision saying that the CE Council can deliver whatever decision they like, but on the other hand, the courts are free to administer injunctions, mandamus, certiorari, and all sorts of other orders in relation to the same proceedings. Now, while we're talking about the proceedings here, can I just take this opportunity to clear out one thing? I heard, before the program comes on, that Dennis Kwok was saying how ridiculous it was that, if the National Party were to appeal, it might run the risk of being offending the law, perhaps being in prison. That is wholly wrong. I wish people would check the facts before publicly speaking out. Under Section 5F of the Society's Ordinance, it is clearly stipulated that whenever appeal is being brought, then the order of the Secretary for Security is automatically suspended until after the appeal is determined. So there is no question that people appealing the decision of the Secretary for Justice will be criminalized, or that people helping them would be committing a criminal offense.
Well, why did the Department?
It's not true.
Why did the Department of Justice then give such an evasive response when the lawyers helping the Hong Kong National Party individual? Why did the Department of Justice give such an evasive response then?
I don't know. You've got to ask them. But it's plainly set out in the statute itself. I would have thought anybody who's bothered to look into the matter, one of the first things they should do is to check what the statute says.
So you're clear there's no possibility that lawyers who provide legal advice to these two...
read out the section to you?
What about after the judgment from the Chief Executive in Council?
Well, what the section says is...
What about during, say, judicial review? Could the lawyers do it then?
Then the order is suspended until after the appeal has been determined.
Yeah, so after that, would they still be in jeopardy if there was during a judicial review?
Well, if they were to to apply to the court for judicial review, then obviously they might have to apply to the court for a suspension order or an injunction or whatever relief that they are entitled to, which, as I said, is clearly open to them at any point of time.
So sorry, they'd have to
They'd ask you mean they'd ask the court to temporarily suspend the order?
Oh yeah, of course. Yeah.
Okay. Now, on what Avon Ng said earlier, he said that this is a slippery slope, or even more than a slippery slope. There's been already the Secretary for Constitutional and Mainland Affairs this week refusing to rule out the possibility that other political parties might be banned. Do you understand the concern that this is not going to be the end of it?
I don't think that's a fair way of putting it. First of all, various countries sometimes do, enact laws to prevent political views which it finds difficult to accept from spreading. For example, the Fascist Party is being outlawed in Italy. The Nazi Party is being obstructed in various ways in Germany, and so on. Now, in Hong Kong, the society order doesn't say that anybody who espouses a different political view from that of the government will be outlawed. Sorry, that is not what the law says. The law simply points out that there are certain instances where, for example, it infringes the ICCPR, that is the International Covenant of Civil and Political Rights, or that it offends, the national security, then the organization may run the risk of being outlawed. So it is not simply that anybody who espouses a different political view would be outlawed. That would be, putting it, I think, far, far too highly without checking the facts. Now, when it comes to whether a particular organization has infringed the law, as I say, there is a procedure that the reasons why a party would be outlawed is spelled out in the statute itself. There is a decision. Anybody aggrieved by it can appeal to the CE in Council without limiting their rights to go to the courts at any point of time, so that the court can look at it and to determine whether the order to outlaw a particular organization is unreasonable and unlawful. Now, how is that not in line with the rule of law, and how is that not in line with a reasonable approach to matters which are controversial to a particular society?
Okay, let's bring in another of our barrister guests this morning, Barrister Philip Dykes. Philip Dykes, the chair of the Hong Kong Bar Association, but appearing this morning in a personal capacity. Good morning, Mr. Dykes.
Good morning.
You take on a lot of cases like this, don't you? You worried that you might end up being prosecuted if you take on this one?
Not at all. There's, in addition to what Ronnie has said in the terms of the ordinance, what it says about suspending orders, there's a constitutional dimension to this as well. Article 27 of the Basic Law provides a guarantee of freedom of speech and, importantly, freedom of association. And this runs into the Societies Ordinance. The issue is an association unlawful under the Societies Ordinance? That's a legal issue concerning your right to associate. That right is protected by, I think it's Article 35, which is very important. Hong Kong residents have the right to be confidential legal advice, access to courts, choice of lawyers, for the protection of their lawful rights and interests, for representation of the courts, and to judicial remedies. So, above the Societies Ordinance, you have that constitutional right. So, the issue is my association lawful or unlawful? That's a legal issue. You have the right to confidential legal advice and the right to representation. And the right to representation would ultimately be before the courts, seeking a judicial review of the decision of the Chief Executive and Council as to whether it was lawful. Not the merits of that decision, but whether the decision was lawful and that it conformed with basic legal procedures and was procedurally fair.
Okay,
and I say that the Chief Executive and Council appeal model is littered throughout the ordinances of Hong Kong. If people were to exercise their rights to appeal simultaneously, the Chief Executive Council would be buried with work. But these appeal routes are very, very common. Some would say they're old-fashioned, that nowadays you would appeal to another body to have it puts too much of a burden on the government at the highest executive level, but the model is long established, and as I say, I don't see any problem in it. Yeah,
it was the governor in council.
Yeah, it was the governing council before. It's now the chief executive council.
So, in short, you wouldn't fear any legal repercussions taking on a case?
No, not at all.
And the fears that have been expressed, though, and we heard Dennis Kwok talking about this before the programme came on air, they're rather overblown in that case.
No, he was. I thought he was really expressing a bit of frustration that the Secretary of Justice could not be more clear about the subject. Because I think, as I said as Mr. Tong, that it's quite clear that if you accept the responsibility of representing such a body or persons under these proceedings, you are not at risk of any sanctions.
Well, I think, as far as I know, the two people under the ban are asking 8 members, I think, of the Executive Council to recuse themselves from this appeal process on the grounds that they've already made clear what their views are on this. Do you accept? Is that appropriate?
If depends on the nature of their views, how they express them, but the body that must make the decision is the Chief Executive Council. That's what the law says. So therefore, such a body should be circumspect in commenting on any proceedings that may come their way. If the person has committed himself to a view that admits of the reasonable belief that this person has made up their mind.
But of course they have. I mean, I know this is legal fantasy land, isn't it? Of course they have. They made the decision. They're not in any sense objective.
No, the actual decision has been made by a police officer in the capacity, I don't know, it's a society's officer. It then goes to appeal. Now, if you're going to comment on the merits of it, I'd say it's unwise for executive councillors to express such a view in advance of an appeal.
OK, well, you said it's unwise for executive councillors to express such a view in advance of appeal. Ronnie Tong, that's something you've done on several occasions.
Well, I'm sorry. In fact, I've openly said many times before that, if it comes to an appeal to the CE Council, I would recluse myself. Not that I hold any adverse views against Mr. Chen or the National Party, but I can understand that because I've spoken out quite a lot in relation to the legal principles connected with this particular situation, and also in particular in relation to the ordinance, that I find it perhaps it would be better if I were to recluse myself. Having said that, I haven't actually noticed that any other member of the council has spoken much in the way that I did. So I don't quite know why it is that it is being said that other members should recluse themselves. In particular, there is this situation of the chief executive itself, which I think poses a slight, some would say, interesting legal question. Now, according to Chapter 1, that is the interpretation ordinance, the CE cannot delegate his or her duties in relation to any appeal to her to any other person. So he or she cannot delegate her right to sit as chairman of CE in council to determine a particular appeal. Now, according to Article 53 of the Basic Law, that if a chief executive were unable to discharge his or her duty, then I think the chief secretary, and then in turn the financial secretary, and then the secretary for justice can step in as acting CE. Now, but I'm not sure that Article 53 can apply to a situation that we have here. So that there's an interesting or grey area, a legal question. Perhaps Philip Dice can comment on that later. That if the CE were decided to recluse herself, whether or not there would be a legal and valid CE in council to entertain this appeal. Now that is a question which I think our lawyers can argue till the cows come home as to what would happen. And I find it a little bit strange that Mr. Chan should ask the CE to step aside, because all that the CE had commented before is her view in relation to independence, not in relation to either Mr. Chan or in relation to the National Party, let alone the ordinance itself.
Okay.
So I'm not sure it is a right thing to ask the CE to sidestep the appeal. Now, the other thing I must mention is that, again, according to Chapter 1 of our laws, it is clearly stated that any appeal to the CE in Council is purely an administrative appeal and not a judicial or quasi-judicial appeal, which means that judicial procedures, do not apply to any appeal to the CE in Council. Now, even though that I joined the Executive Council, only very recently, we have entertained one or two appeals, over the last year in relation to various other issues, and inevitably the appeal was being dealt with on paper, in the sense that we look at, what is being said, the grounds of appeal, we look at the relevant department's response, and then we debate it amongst ourselves in relation to the matter, and then the CE in Council will come into a decision. So that is not a judicial process as such. There will be, as far as I understand, no hearing, so that all the arguments are being put out on paper, and we'll look at it. Now, that being the case, I think to try to bring in considerations of legal procedure to the CE in Council is, I'm not sure, is the correct way of doing things.
Okay, let's bring in the fourth of our guests, Lawrence Ma. Lawrence Ma, barrister.
Hello, good morning.
Good morning, barrister and chairman of the Hong Kong Legal Exchange Foundation. What's your view on this, particularly the concerns that have been expressed over the past few days about the whether lawyers will be affected?
Well, I think both senior lawyers, Philip Dietz and Morning Tong, has summarized the law pretty correctly. I would see further away from this appeal, because this administrative appeal or review would probably eventually go into court on a judicial review of an administrative decision of the Chief Executive in Council. So that if the matter actually goes to court, it would give the court a very good opportunity to determine what is the line to be drawn with respect to freedom of expression vis-a-vis national security. Now, in many European jurisdictions, it seems the line to be drawn is violence. Now, the issue then it comes down to whether Mr. Chan himself and the party has in any way incited violence or in any way associated with terrorists, for example, when he was presenting in a meeting and conferences in Xinjiang. This would be a very interesting issue.
I think you mean about Xinjiang. I don't think he's ever been in Xinjiang, surely?
No, yes. He was in a meeting with some of the representatives who came from Xinjiang, and those were being banned by our by the State Council, the Public Security Ministry, as terrorist organizations, some of them.
So sorry, I have to interrupt you there. You're saying that the fact that he's been in a meeting with an organization that has been banned under mainland law that does not apply in Hong Kong should then become relevant when we're deciding the issue of the legality of his organization in Hong Kong?
Oh yes, when you're seeing it from the angle as to whether the person has actually participated in action and discussions, and if there are factual evidence to show that the person has actually formed associations with people who are in fact terrorists, then it would be very strong evidence to say that national security is in threat. because those people, Xinjiang representatives, were advocating the independence of Xinjiang.
Okay, sorry, Lawrence, I'm just going to stop you there because Ronnie Tong is leaving soon. I want to go back to Ronnie Tong on that point. You just heard what Lawrence Ma said. Would you agree with that evidence of activities that might have breached mainland law can be taken into account?
Well, I'm not sure I agree with that. I would simply look at the four corners of the statute and to see if, the facts revealed by the Secretary for Justice brings the case within the four corners of the statute. And the statute simply says that if somebody were to form a party whose aim may affect the public safety and protection of rights and freedoms of people in Hong Kong, or may affect national security in the sense of territorial integrity and the independence of the People's Republic of China, if there are such facts, then of course the Secretary would be entitled to make an order. Now, in relation to gathering those facts, would it include facts that about what has happened on the mainland? I would say yes, that's possible, but the fact that you have something which happened in the mainland or the mainland authorities have taken a certain view is not determinative of whether or not a party should be outlawed in Hong Kong under the ordinance. So
okay.
I think one must be clear about the distinction.
All right, okay. Well, we're out of time. Ronnie Tong, thank you very much indeed. We're going to continue the conversation after the news, and I think we've got to say goodbye to Ronnie. For the moment, we'll continue, as I say, in 3 minutes. The weather, sunny periods, visibility relatively low in some areas. Temperatures up to 28 degrees, 25 degrees the latest. Relative humidity, 78%. Welcome back. This is Backchat on a Friday morning with Danny Gittings and me, Hugh Chiverton. We're talking about the National Party's appeal against their ban, talking about some of the legal aspects of that. We had Ronnie Tong in the first part of the programme. We also have now Lawrence Ma, who's a barrister, chairman of the Hong Kong Legal Exchange Foundation. Barrister Philip Dykes, who's speaking in a personal capacity, not on behalf of the Bar Association. And Avery Ng, who's chairman of the League of Social Democrats. Later we're going to be also talking about Cathay Pacific, that leak, that loss of information of some 9.4 million Cathay Pacific passengers. Your thoughts on any of those topics? Very welcome. Please share them by emailing backchat@rthk.hk and we'll read them out. Or you can go to our Facebook page as well. That's Backchat on RTHK Radio 3 and read out what's there. Let's see. An email first from Fergus, who says, Independence, the Court of the Star Chamber meets. Poor chaps, the pair are totally screwed. The quasi-court is blinded by loyalty to Beijing. Plain blind bias. Facts don't come into it. Supposition, conjecture, paranoia do. It's all done in secret with foregone arbitrary conclusions. It's an appeal to the same lot that decided their original ban, so not an appeal in any proper legal sense. Once Beijing has requested and endorsed the ban, which it has it's a done deal. No going back. It's the SCR equivalent of the 15th century Court of the Star Chamber. You can be very proud, Ronnie. You have made it to the pinnacle of justice. Carrie will again claim victory for the rule of law, but again she has that myopic, perverted version of what the rule of law is. When her liaison office-led team has their hands on it, it becomes ruled by men. But it's a soundbite, she repeats, ad nauseum, to somehow reassure us. We are vulnerable having a leader with this myopia, and that's the very reason why the Independence Party has come into being. They saw no hope in homegrown solution to Hong Kong issues. The Independence Party is the love child of C.Y. Leung and Carrie Lam. Without that pair, it would not exist. Ask Ronnie what was the threat to the public order that that led to the ban in real terms. Let him give you some facts without hiding behind some murky scenario and national security. Facts and evidence, Ronnie. Don't hide behind the basic law as you will do, I know. At the time of Occupy, there was some makeshift bombing materials found in some old ATV studios, and the pro-establishment camp immediately tried to link this to the independence movement, all blind conjecture. If truly there was a rule of law, there would be transparency about this ban. There is zero transparency. There were over 100 road deaths last year. Do we ban cars on the basis they're a threat? That's a measurable threat at least. No chance of fair hearing. It's an arbitrary government which runs at the behest of Beijing. The government purports the recommendation to ban came from the police. The police used to be an evidence-based force. So is the Hong Kong police now using a crystal ball as part of its toolkit? The credibility of the government is lost here, a loss to fair, open-minded people. That's Fergus's take.
And on our Facebook page, TC addressing the issue of whether lawyers who represent Hong Kong National Party founders might run into legal trouble themselves. TC says, a logical point about legal representation. Lawyers representing accused first-degree murderers doesn't mean that he or she is aiding criminals. It can simply be wanting a fair trial. Another example. One can't say that lawyers defending the accused in the Nuremberg trial were aiding Nazism. Thank you very much, TC.
And one more comment on sort of slightly off the topic from Matthew, who says, I thought the question Hugh raised on Monday regarding whether it was possible for Backchat to interview Andy Chan was interesting and worth its own programme to debate. Love to hear the views of government officials and regular pro-CCP Backchat guests on this. Perhaps Lawrence Ma or Ronnie Tong can give us their views. So Lawrence Ma, if they think it's okay for Backchat to interview Andy Chan, but then Hugh got in legal trouble or had visa difficulties as a result, would they be willing to represent and defend Hugh in his legal proceedings? That question asked by Matthew.
Hugh,
Lawrence Ma, would you be my barrister?
Well, I mean, lawyers. I agree with Philip to the extent that yes, we defend criminals in trials, and we are not then become a criminal. But there are rules of the bar that for example, we cannot give legal advice on how to evade a tax system, for example, or how to design a criminal plot for fraud, for example. Now, if that is our ethical duties. Now, with respect to representation strictly in court and giving legal advice on the law, I don't think we are in trouble. But with respect to other things, such as devising a plot and helping people to evade tax, I think that gets us into trouble.
I mean, you could argue that you're sort of painting a picture of contagion that's so powerful that if somebody meets somebody else who is who may have some sort of a criminal associations, then they should be outlawed in some way. Do you see what I mean? You were saying that the National Party, because they had met some people from a Xinjiang group, therefore should be banned and became a threat themselves. So if I interviewed Andy Chan, would I become a threat? Would I have to be banned because I'd be somehow a threat to national? And would you be banned because you're talking to me?
I can't answer that question.
Is this incitement to incite?
It is a grey area whether how you, for what purpose, and whether you are wanting to further his cause of inciting independence, for example. If you are, then that would be a problem. But if you're purely discussing an issue of law as to whether, on the legality of the decision, then that would be different, I think.
Okay. Let's just got some emails. Let's get to this one by Bowen before we move on. Bowen says, Dear Backchat, the fact that Andy Chan's lawyers felt the need to write to the DOJ for an assurance that providing legal assistance to Chan would not be regarded as providing assistance to the Hong Kong National Party is astounding enough, given that under existing procedure, the National Party had until the day before yesterday to file an appeal to the Executive Council. If an appeal is allowed, why should lawyers get into trouble for providing legal services to facilitate the appeal? Equally astounding is the reply, which reportedly says that no such assurance can be given, nor can any pledge be made that the lawyers would not face prosecution in future. Is Hong Kong fast deteriorating into the mainland's rule by law? It would appear not after the explanation just given. It would appear not. After the explanation just given by Ronnie Tong. Priscilla Leung's few comments reported this morning did not allay concerns, as she said that it was difficult for the government to say whether Chan's lawyers would be prosecuted because, quote, we don't know what would go on with the team or their strategy, unquote. Does that mean the legal team may get into trouble if they are too good, or they manage to come up with clever legal arguments to beat the prosecution? Her remark could also be used to interpret another of her subsequent comments that, quote, legal representation is purely to help the court and also the judiciary to make the necessary decision over the matter. matter, unquote. Maybe this is exactly what society is worried about. The role of lawyers in our society is not just to help the courts arrive at the decision that the government deems to be necessary. That sounds more like the role of lawyers in the mainland's legal system. When Thomas Paine was prosecuted in England in 1792 for seditious libel against the Crown on account of his authorship of the Rights of Man, few public men would have dared to defend him. Paine had previously been one of the architects of the American Revolution. Thomas Erskine, a barrister at the height of his career, was offered the brief to defend Paine, and all his friends at the bar and the bench begged him not to accept it, but he maintained he had no choice, that the traditions of the bar gave him none. In the famous opening words with which Erskine began his speech at the trial, he said that he asserted the independence and the integrity of the bar, without which impartial justice could have no existence, that if any advocate could be permitted to decide whether to stand between the Crown and the subject arraigned in court, England's liberties were at an end, and that any advocate who refused to defend from what he may think of the charge or of the defence would usurp the role of the judge and prejudice the case of the accused. That these words may need to be repeated to Hong Kong's lawyers in the 21st century would seem surprising enough, but it should be added that Erskine was only speaking out against the possibility of advocates refusing to defend an accused because of what they might think of the charge or of the defence. He was certainly not entertaining the possibility that any advocate might have to worry about being personally prosecuted for defending an accused client. In other words, even in 1792 there was no possibility of that happening in a civilised country. Erskine himself only lost his job as a legal adviser to the Prince of Wales as a result of his association with Paine's case, and in due course became Lord Chancellor in 1806. It's the lawyers in Hong Kong 226 years later who have to worry about the almost unthinkable spectacle happening. One would have thought that if a Hong Kong lawyer were to go to jail one day just for providing legal services to a banned political party, say in an appeal process, that might become a noteworthy event in the common law world, albeit of a somewhat shocking and ignominious type.
OK, thank you very much, Bowen. We have a caller on the line, a caller who will be familiar to many of our listeners, Grenville Cross. Grenville Cross was Director of Public Prosecution for 12 years. Good morning, Mr Cross. Thank you for joining us.
Yeah, good morning, Danny.
What are your thoughts on this topic?
Well, I think there's been a little bit of confusion in parts of the discussion, and I hope you won't mind if I mention them. There are, in fact, two methods by which a society can be prescribed under the ordinance. The first part is under Section 5, as Ronnie Tong says, and that occurs when the society's officer himself cancels the registration of a society or the society's exemption for registration. Now, in those circumstances, if there is an appeal from the society's officer's decision, then the decision itself is frozen until the appeal is over. Sorry, I beg your pardon. The society's yeah, that's right. The decision is frozen. In other words, the society is not unlawful during the appeal period. However, this is the all-important point. Under Section 8, the Secretary for Security himself, not the society's officer, the Secretary for Security himself can prescribe the society by an order in the Gazettal.
This is what's happened here, right?
Gazettal, yeah, in the Gazette. And that's what's happened on this occasion. And subsection 6 of Section 8 makes it clear that if there's an appeal in those circumstances, then it doesn't affect the order itself. In other words, if the society is prescribed under Section 8, then even if there's an appeal, the society remains unlawful until the appeal is determined.
You're completely right. And,
Thank you very much.
Ronnie Tong's completely wrong.
Well, Ronnie Tong's not here to defend himself.
So in fact, one other point on that, of course, it's not, as someone suggested in the course of your discussion, the society officer's decision which is being appealed. It is the decision of the Secretary for Security.
So, in fact, thank you very much for clarifying this. In fact, those who defend or who assist in an appeal, they could conceivably be in some legal jeopardy. I mean, it depends on the facts, but that's presumably why the Department of Justice responded with a non-answer when they were asked about this, because it's impossible to know whether they would actually wish to take criminal action against someone who's aiding the members of the Hong Kong National Party in such an appeal, right?
I just pointed out that there is a constitutional right to legal representation, and it's unthinkable that someone who is simply doing no more than providing legal representation for the purposes of an appeal would ever be prosecuted. I mean, it may technically be an offence, but that's by no means a given. But it's unthinkable this would ever happen, and it's rather surprising that the Department of Justice hasn't given the assurances which were sought.
You think if you were still in the DOJ, you would have used stronger language to provide the assurances?
It's not about having no view. I mean, even if technically an offence might arise, it would be for the Department of Justice to say that provided a lawyer simply provides legal advice for the purposes of the appeal, there could be no question of a prosecution. Quite clearly, a prosecution in those circumstances wouldn't be in the public interest.
But lawyers would be vulnerable.
I'm sorry?
But lawyers would be vulnerable. They could be prosecuted.
Well, I'm just saying that technically there may be an offence. I mean, I'd need to look at it more closely. But assuming it might technically be an offence, then there could be no question of prosecuting in those circumstances, and the lawyers in question should be given the assurance that they sought.
So you think the Department of Justice has mishandled this, and they could have allayed it?
They're sitting on the fence so far, and they need to look at it a bit more closely. And when they do so, I'm sure that they will give the assurances that are required, naming assurance that it would not be in the public interest to prosecute anyone for simply giving legal advice for the purposes of an appeal.
Philip Dykes, there's strong language from Grenfell Cross there. Would you agree that, Philip Dykes, that the DOJ mishandled this?
They were not as robust and as forthcoming as they might have been, and as the persons who sought the reassurance might have expected. Like Grenfell Cross, I take the view that providing regular legal services by advice and guidance on how to prosecute an appeal to the Chief Executive Council will incur, I don't say it's technically, it could be technically an offence, it is not an offence.
Okay, and Grenfell Cross, on the issue of whether other organisations may be banned, do you have any view on that?
Well, I mean, the criteria are clearly set out. I mean, the Secretary for Security only acts on the grounds of national security and public order and so on. And so there has to be a very real risk of those situations arising before any question of a ban would arise.
Because this has been raised, and the government has given evasive answers. Presumably on that, you would support the government giving evasive answers because they don't know whether they might wish to other organisations might meet this threshold at this stage.
Well, as you know, the Secretary for Security in this particular case produced, if I could call it that, a 7-page indictment identifying the matters on which the society and its officers were alleged to have transgressed. And obviously, if those same circumstances arose in relation to some other society, then the same situation would arise. But there's no reason, so far as I'm aware, to suppose that will happen, certainly as things currently stand.
And earlier on this show, you were probably listening, Lawrence Marr, who's still with us, said that in the decision to ban the Hong Kong National Party and the appeal against it should take into account that they've been associating with organisations who have been banned under mainland Chinese law. Would you agree with that criteria?
Well, I mean, if the result of associating with organisations in other places is that there is a threat to national security, then it's clearly an understandable position.
Even if it means looking at decisions that have been made under mainland law that does not apply in Hong Kong.
Well, as I say, the test at the end of the day is whether the association with organisations elsewhere is a threat to national security or poses a threat to public order here.
Avery, do you want to come back on some of these points?
Well, the thing is, I have to remind people that we talk about all these legal procedures with regards to the appeal, but the simplest fact is that there is a line, and that line is national security. And I suspect that this whole appeal process will go up to the higher courts and do the rounds, and eventually will come down to a judge in court, or worse, a reinterpretation of basic law by the People's Party. You
mean the National People's Congress Standing Committee? We don't actually have interpretations by the Communist Party.
Sorry. Well, same thing. But anyway, and then there will be probably I worry that there will be a clear and very strict view on what constitutes a threat to national security. And that means in effect, we've got a de facto Article 23 before we actually legislate for Article 23.
So you think this could all end in an interpretation by the National People's Congress Standing Committee?
If it goes up to the ultimately to the Court of Final Appeal, because if we really use the logic of basic law and the precedents, I cannot see any way that these two guys who advocate independence on the internet will constitute an immediate threat to the national security.
You're talking about quarterfinal appeal. That's years away. Will these
exactly,
will they still be around? They'll probably have gone to Washington or something by then.
Exactly. Well, that's the thing. The government is using all these administrative procedures and the burdens of going through this legal process to obstruct people from actually expressing their view.
Okay, couple more comments. Pete says, it's all very well what Ronnie Tong says about the law. This will not stop the Director of Immigration refusing to renew visas if lawyers in this case happen to be foreign nationals. Perhaps the visas or even permanent residency can be rescinded. The Director of Immigration does not have to explain himself. Or am I being unfair? That thought comes from Pete. Lawrence Marr, you might say, look what happened to the journalists who gave a platform for the National Party. Maybe lawyers will suffer the same fate, and the government won't have to explain anything.
Well, I think we should draw back from viewing it from a different angle. As lawyers, we have duty to the law, we have duty to the court, and duty to the client. Now, duty to the law means that we are not going to devise a plot to assist people and advise people how to break the law. Now, but representing someone who has already broken the law or is presumably broken the law,
but they're in a strange situation, aren't they? Because you commit an offence by aiding them, by aiding the party, and if this is considered to be aiding the party, and you would have thought that acting for them in a legal position was aiding them, then you would be liable.
Yes, so if you assist them,
so you would commit an offence by representing them.
No. But if you assist them before the fact, that you will be aiding them. But if you represent them in court and give them legal advice as to how to defend themselves in court, that would be after the fact. So I don't. But
it is after the fact because they're a banned organisation, as Grenville Cross has explained. That there is no suspension. This is an illegal party. This is a party which it is an offence to aid at this moment.
Yeah, but that section 8 of the Societies Ordinance prohibiting aiding and abetting of those banned societies would have to withstand the scrutiny of Basic Law Article 35, which allows people's right to legal representation as a constitutional guarantee.
Grenville Cross, now you've clarified that this order against the Hong Kong National Party is not suspended during the process of appeal. Would we be liable on Backchat here, would we be aiding and abetting the Hong Kong National Party if we invited Chan Ho Tin on? What would your view be as a former DPP?
Well, you enjoy freedom of speech and freedom of association. Of course, under the ICCPR, the simple exchange of views.
Tell that to the FCC.
Well, they haven't actually been criminally prosecuted.
In my view, a simple discussion of an issue does not amount to any sort of offence. Even though if you overstep the mark and started advocating doing anything to support or promote the party itself, then that would be a different matter.
But would any media organisation be supporting or promoting the party if they gave a platform to one of the party's members to speak out publicly?
Well, the party, of course, as you say, is now illegal, and provided the person wasn't purporting to be there as the spokesman or the representative of a banned political organisation, and was simply there to express a view about a current political issue, then that would fall within the protections of the International Covenant on Civil and Political Rights, in my view.
Okay, thank you very much. And Philip Dykes, your opinion, are we in legal jeopardy here in the media?
Well, you should certainly seek good legal advice. And as you're a government department, you would go to the Secretary of Justice.
Yes,
I'm sure she would tell you exactly what your position is.
I'm sure she would, yeah.
Yes, that's the way for you.
Thank you very much. Might not be so much of assistance to private sector media organisations.
Okay, we're off to talk to our lawyers. Thank you very much indeed, Philip Dykes, as a barrister, speaking in a personal capacity, not on behalf of the Bar Association. Thanks to Avery Ng, Chairman of the League of Social Democrats, to Lawrence Marr, barrister, Chairman of the Hong Kong Legal Exchange Foundation, and also to Grenville Cross, who just joined us then, Ronnie Tong, speaking in the first part of the programme as well. 9:25. Finally today and this week to the issue of Cathay Pacific and that leak of some of information from some 9.4 million Cathay Pacific passengers that occurred. It happened earlier this year, and there was a significant delay. I think it was 7 months before the information was made public that this leak had occurred. There's been a lot of criticism of the airline, of course, over this and their treatment of it. Michael Gaisley joins us now. He's Managing Director of Network Box, concerned with internet security. Mr. Gaisley, good morning to you.
Yeah, good morning.
Thanks for joining us once again. How significant is this? I mean, it's fairly sort of frequent occurrence these days, isn't it, that you get these kind of data leaks?
Unfortunately so, and the usual advice of, change your password at the end of every article about cybersecurity obviously doesn't apply, because as more and more of our data is collectively stolen and put onto the dark web eventually, this data gets added together and the criminals have a better and better